Petitioner, you may begin whenever you're ready.
Good afternoon.
Good afternoon.
Good afternoon.
May it please the court, Noah Levine representing the petitioner. This court must reverse the Ninth Circuit's decision to acquit the respondent of his 4 convictions due to the alleged denial of his Fifth Amendment rights. Now, the respondent may argue about the unambiguous nature of her client's exclamation, quote, "I don't want to talk no more, man. You don't want to hear what I'm telling you." The respondent may argue that questioning ought to have ceased immediately following the statement. At the end of the day, it's neither up to me nor the court to determine the intention of the respondent's statement. This case is solely about the Ninth Circuit's misapplication of AEDPA, solely about the necessity to adhere to federal statute. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, the Ninth Circuit Court was able to grant relief only if the lower court's decision involved an unreasonable application of clearly established federal law. Your Honor, the standard set by AEDPA is a high one. Unreasonable application. This means that the Ninth Circuit was only lawful in overturning the lower court's decision if it discovered an application of law that was irrational, that was lacking justification such that no fair-minded disagreement could be had. This case presented a distinct challenge to the lower courts given how unclear the right to silence procedure was at the time of the original hearing.
It seemed, though, that when Tompkins was issued in 2010, this court didn't seem at all troubled by or surprised by applying the same standard, which is to say that we said there was no principled reason not to do so. And there are lower courts that actually applied the right to counsel standards to right to remain silent based on that idea that there would be no principled reason to differentiate between the two. And so isn't it the case that Tompkins didn't really articulate a new standard at all?
Well, I think while Tompkins has no legal bearing on the case today, its presence itself shows that it was in fact necessary. There would have been no need for Tompkins to have explained this new standard for a right to silence claim having the necessary procedure that the right to counsel claim has if it was already in place. So while there may have been precedents for right to silence claim having the same procedure, there are also precedents otherwise.
And so what did the trial court rely on in terms of the law that it looked to look at the context of the invocation in order to render it ambiguous? In other words, what case law permitted the trial court to do that?
So one of the only precedents at that time regarding right to silence cases was Miranda v. Arizona. Miranda v. Arizona was successful in that it brought to light this issue of right to silence and Fifth Amendment rights, but it was unsuccessful in that it made this very ambiguous procedure by which the courts could look at whether one actually invoked their Fifth Amendment right or whether they were just equivocating or rattled from the interrogation. And so while the courts could look at this for an example, there wasn't an unambiguous procedure to follow to determine whether the respondent was actually invoking his Fifth Amendment right. One of the only true precedents for this case, as I just said, was Miranda v. Arizona, and it had those failures. Now, the Davis v. United States decision acutely set a standard for right to counsel claims, that assertions must be unambiguous. However, as Miranda split the right to counsel and the right to silence, it was entirely unclear to the court at the time whether the right to counsel system, procedure, should count to a right to silence claim, until Burgess v. Thompson. Now, the Burgess v. Thompson decision is crucial to the proceedings here today. Decided after this case was originally tried, it finally set the same standard for right to counsel and right to silence claims. Its mere necessity shows that at the time of the original trials for this case, the standard for right to silence claims was entirely ambiguous and needing justification, needing clarification. I'm not arguing that the respondent never asserted his Fifth Amendment right. I'm not asserting that all the state courts and federal courts made the perfect decision. I am arguing that the unclear standard by which the courts were asked to assess the respondent's Fifth Amendment declaration show that it was entirely reasonable for them to find that he did not, in fact, invoke his Fifth Amendment right.
Thank you.
Good afternoon.
Afternoon.
May it please the court, Forrest Wallace for the respondent, Kevin Jones. Kevin Jones unambiguously invoked his right to silence after being interrogated for hours late into the night. And thus this court should uphold the Ninth Circuit Court of Appeals ruling that he did in fact invoke his right to silence. The petitioner has told you that it's not about whether he unambiguously invoked his right to silence. It's about the standards that existed at that time. What we will show you today is that not only did Kevin Jones unambiguously invoke his right to silence, but the standards that existed at that time are no different than the standards that exist now. To begin with, Kevin Jones's invocation of his right to silence during his interrogation was unambiguous. Kevin Jones, after being interrogated for hours, sitting in this interrogation room cold, said, "I don't want to talk no more, man."
So what about this notion, though, that we have the "I don't want to talk no more, man"? Then we have, I understand that, but the bottom line is an interruption of "you don't want to hear what I'm telling you." And it was that sort of colloquy, maybe a few lines before or after, that the trial court found cast a doubt on the clarity of maybe even the intention of invoking a right versus just expressing frustration. What prohibits us sort of from looking at that extra language, even if we grant you the idea that the invocation is clear? Why can't we look at the language that comes after to make it, to render it ambiguous?
2 points in response to that question. First off, Miranda v. Arizona set clear standards that said that after an individual invokes their right to silence, the interrogation must cease. That means no more questions, no more talking on the detective's part, the interrogation ends there. That gives us the precedent for not looking at the remaining lines or the preceding lines in this case.
So I know you said you have 2 points, and I'll let you get back to your second one. But before you do, aren't the police officers allowed to ask follow-up clarifying questions after an invocation?
Yes.
And so
Well,
couldn't that have been what's going on here is I guess my concern. If they're allowed to follow up with a clarifying question, how do we know that that's not what happened here or was going to happen here?
We do not know that. However, it is clear that his invocation of his right to remain silent was unambiguous, even including his second statement in the larger context. Jones responded to the detective's continued pressuring and said, "You don't want to hear what I have to say." That's simply an explanation of why he doesn't want to talk anymore, and it does not make his original request ambiguous. In fact, after that, the detective continued to pressure them and pretended he did not hear what he said the first time, after having already acknowledged that he heard what he said the first time. And thus, this is not a case of clarifying questions. This is a case of trying to dodge that right and trying to manipulate our client, Kevin Jones, out of his constitutionally guaranteed right to silence.
Are you saying really and truly that there is no sort of even arguably ambiguous or equivocal statement such that the trial court's order should stand? I mean, that's really the standard under AEDPA, right? That the trial court acted just completely unreasonably. And the petitioner has argued that there really weren't any guiding principles or standards. And so can we really reach down and overturn that decision with any of the lack of guidance?
There was already guidance. In Miranda v. Arizona, the Supreme Court ruled that after invoking their right to silence, the interrogation must cease. Tompkins was simply a clarification in which the Supreme Court told the lower courts, essentially, we don't understand why you're confused about this, but here are some clarifying guidelines. According to the Supreme Court, they had already ruled clearly about the standards to be applied and were baffled by the lower court's confusion in these issues, and thus felt the need to clarify. However, they did not change the standards by which these rights are invoked or applied.
All right, good job, guys.